How does a second-degree felony for indecency with a child get reduced to a misdemeanor? In this shocking courtroom footage, a defendant pleads guilty to the lesser charge of indecent assault. But the case takes a dramatic turn when the judge reveals the victim was only 10 years old and delivers a sentence that goes beyond the plea agreement.
This indictment alleges that on or about March 10th, 2021 in Jefferson County, Texas, you committed the second-degree felony of indecency with a child. Do you understand what you're charged with here?
Yes, sir.
If convicted, you face a term of not more than 20 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
An agreement has been reached where you would be pleading guilty, prosecuted for the lesser included offense of what is the offense?
Indecent assault.
What's the section number? 20. I got 22, I guess. Indecent assault 22.012. A person commits an offense without the other person's consent with intent to arouse or gratify the sexual desire of any person, such as the breast of another person. This is a Class A misdemeanor. So the punishment range is not second-degree felony, which is found under Section 22.012 of the Texas Penal Code, which carries with it up to 1 year in the county jail and or up to a $4,000 fine. Do you understand the punishment range?
Yes, sir.
The agreement is that you would be placed on deferred or unadjudicated probation for 2 years. Is that your understanding of the agreement?
Yes, sir.
Also, fine $500.
Yes, sir.
If I follow that, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this Class A misdemeanor, lesser included offense under this indictment? Indecent assault, guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty?
Yes, sir.
Show you what's marked as State's Exhibit 1. Did you sign that document?
Yes, sir.
Understand it? Discuss it with your attorney? Are the contents all true and correct?
Yes, sir.
State's Exhibit 1 is tendered into evidence.
Objection.
Without objection admitted. Among other things, this states you are mentally competent to enter your guilty plea, which is freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged in any lesser included offenses. You were giving up your rights to a jury trial and the right to the appearance, confrontation, cross-examination of witnesses. You were totally satisfied with the representation provided by your lawyer. All of this is true. It states, so help you God.
Yes, sir.
Is that true?
Yes.
State's Exhibit 1 is made a part of the record for all purposes. I think I understand all of this here. How old was the child? 10 years old?
Yes, sir.
The only difference between this and the second-degree felony of indecency with a child is the fact that y'all just dropped the age of the victim, right, as an element.
Yes, sir.
Everything else is the same.
Yes, sir.
Okay. It looks like sex offender registration is not required yet.
It's not mandatory. No, sir.
And it didn't get passed in this term, I guess.
No, sir. Not to my knowledge.
The statute says it's sexual offender registration is not required, and then it's in parentheses yet. So apparently, for whatever reason, they elected not to. The legislature elected not to change that other code. All right, and the defendant has entered his plea of guilty to this Class A misdemeanor. Is a pre-sentence report waived?
Yes.
Anything else to add? If not, I'm going to find Mr. Hernandez, you have pleaded guilty to this Class A misdemeanor, the lesser included offense of what is referred to as indecent assault. And under section 22.012 of the Texas Penal Code. You have pleaded guilty voluntarily. You are mentally competent to do so. You understand the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. However, I am going to follow this agreement, defer any finding of guilt, and place you on deferred or unadjudicated probation for 2 years. You are fined $500. There will be terms and conditions of probation, which are normal and customary for this type, a general type of offense, even though I'm wanting to go to sex offender classes and other things like that, that are normal and customary for other types of the offenses. And especially in light of the fact that the complainant was 10 years old at the time of this event. There will be other terms and conditions of probation which are normal and customary for this. Now, you're also going to do 180 days in the county jail. This is a crime of indecency. A 10-year-old child is victimized. You're going to pay a price for irreparable harm to a child on my watch. I just wish it was more. You took advantage of a 10-year-old more than once, according to the probable cause affidavit. And except for everybody just dropping the age, it's a second-degree felony. Plus mandatory reporting requirements for life, I believe. What this court can do in managing the fair and appropriate remedy that I guess we can assess, although how do you take back the harm to a child? There is no way. You took advantage of a child. I have no sympathy for you. I have sympathy for the child. You took advantage of a 10-year-old child. Shame on you. You're going to jail immediately, 180 days, as a condition of this probation.
Your Honor.
Anything else?
Yes, Judge, if I may, considering that he's employed currently, will the court allow us to break that up in some way? I don't have something to proffer to the court right now, but I would at least like to ask the court to,
Let me just say,
to consider.
Mr. Kelly is one of the most wonderful people I know. And he's a wonderful attorney, as well as just being a very fine, great man. He has children, and I know what he thinks. I know what we all think. You didn't give this child a chance to get ready for your assaultive behavior. And you did this more than once. And I have no sympathy for you. I'm not going to work on your terms in spite of the fact I would do almost anything for Mr. Kelly. This doesn't have anything to do with Mr. Kelly. He's trying his best to help you, but he cannot undo your terrible misdeed. It was an unnatural act you performed on a child. Shame on you. You're going to jail. The most I can put you is 180 days. And that's what you're getting. That's what we call justice under these circumstances. Unfortunately, we can't undo the assault that you performed on a 10-year-old child. Shame on you. Anything else? That's, in all due respect, if it was any other kind of circumstances, Tom, but I feel sorry for that child. That is all.
While the plea deal for misdemeanor indecent assault allowed for probation, the judge's condemnation was absolute. Citing the exploitation of a 10-year-old child, the court imposed an immediate 180-day jail sentence. The judge's final words, "Shame on you. You're going to jail immediately." This case highlights the tension between legal negotiations and a judge's discretion to demand accountability for harm done to the most vulnerable. Thanks for watching.